A heartbreaking story out of Wisconsin. Police say two parents planned to sexually abuse their baby before she was even born. Detectives say the two exchanged messages, reportedly discussing in detail how they would carry out the abuse. The baby was just a couple months old when the alleged abuse began, and some of it was reportedly captured on camera. Now, the infant is in protective custody and her parents are behind bars. I'm your host, Kennedi Walker, and I'll walk you through the disturbing allegations. This TikTok video shows Skyler Klassen and Madison Bishop's gender reveal, biting into cupcakes, discovering pink icing, and learning they're having a baby girl. They're laughing, crying, seemingly overwhelmed with joy. But just months after bringing their daughter home, that joy would turn into disbelief. Both parents were arrested, accused of abusing the very child they once celebrated. Shortly after birth, the baby girl was placed in the NICU. Bishop shared this video online, captioning it, quote, "It's the worst pain I've ever felt, like having my heart ripped out every time I walked out the door." But investigators say it wasn't until the baby left the hospital and came home that the real pain began. According to court records obtained by WKOW, detectives with the Madison Police Department's Special Victims Unit received a tip. Skyler Klassen was allegedly in possession of child pornography. On April 9th, police arrested the 22-year-old. A search on his phone allegedly revealed multiple files, including, authorities say, a video of Klassen assaulting the 2-month-old. Detectives say Klassen allegedly confessed to the abuse. At the time of his arrest, he had an active warrant out of Nevada regarding child sex abuse material. While combing through Klassen's phone, investigators say they found images of the baby's genitals and a video that allegedly shows the 2-month-old being digitally assaulted. The assault reportedly happened April 7th, just 48 hours before Klassen was arrested. According to the criminal complaint, detectives also uncovered a series of graphic text messages between Klassen and Bishop. Messages that revealed the alleged abuse was planned long before the little girl was even born. The disturbing conversations reportedly continued after her birth, describing in detail what they wanted to do to the newborn. Documents allege the couple also discussed selling the child and frequently exchanged child pornography, including images and videos involving other children. Skyler Klassen now faces a long list of charges, including first-degree child sexual assault, incest with a child, 4 counts of child exploitation, and 4 counts of possession of child pornography. Madison Bishop was arrested 1 week later. She was charged with 1 count each of first-degree child sexual assault and failure to protect a child. And joining me to talk more about this is legal expert Bridget Williams. Bridget, thank you so much for coming on today. Let's just jump right in. What exactly constitutes first-degree child sexual assault?
Hi, Kennedy. Thank you so much for having me. What constitutes as just child abuse, child sexual assault can really run the gamut. There can be multiple things that cause that. Here in Texas, we can have penetration. It can also be other things where it may be fumbling or necessarily touching. All of those things still constitute sexual assault of a child, someone who is 18 years or younger. And so these specifics may vary from state to state, but the ground rules around it normally are going to be inappropriate touching or penetration of someone who's younger than the age of 18.
What do prosecutors have to prove for a charge of failure to protect a child?
Failure to protect the child. That's going to really, again, that's going to vary from state to state. Every case, whenever we talk about a criminal matter, that is state-based information. And so when we talk about failure to protect the child, again, that can be something where they may have intentional or like recklessness, where they did not provide protection to the child. So that can be, again, it varies from state to state. That's not necessarily something that we can say specifically what happened here in Wisconsin, but that can be a state by state basis.
Can both parents be charged with the same crimes even if only one allegedly physically committed the assault?
110% yes. If each person was involved in the planning of a particular crime, then each individual can be charged with the actual offense. If another person was the planner and the other person was the actual executor of what happened, then both individuals can be charged with the same crime and both face the punishment phases of each of those crimes as well.
Yeah, such a just a sad and horrific story. How do investigators authenticate videos and photos as evidence in court? Because according to documents, police say that that's how they were able to put everything together through alleged videos that they found on Skyler Klanson's phone.
That's a great question. I think we talked about it a little bit prior to getting on this call, where the officers start off by either getting a tip or some kind of way where they're going to be able to get information, media, or something that may be a recording. They get a warrant for that information, and that's just how they would get information for any investigatory type of information to prove up a case. Once they get that warrant information, to actually collect the data from a cell phone or anything like that, then they have the authority at that time to collect that data from it. When they move forward with that, the police department will put together a packet. They present that to the DA's office. Then the DA's office will present that case to a grand jury if it's a felony. In this situation, it is. Then it moves forward to the grand jury. If they decide they're going to move forward and say some probable cause was enough, then it moves forward to an actual court setting. And then at that time, if it moves forward to a trial, then the DA's office has to authenticate that information via trial for it to be proven up in evidence.
Now they're saying that one of the suspects, Skyler Clanson, he had a warrant in another state. How does the presence of a prior warrant in Nevada impact Clanson's prosecution in Wisconsin?
It definitely does impact it because what will happen is that that information will be used in the negotiations between the state and his defense counsel whenever he decides that he's going to hire a defense counsel, if he has a public defender, whoever it is. That information will be brought up, not only because he had a warrant, so that shows that he is more than likely unstable. He is someone who didn't show up to court previously, and that he is someone who absconded from the responsibilities of that case in Nevada. That will also come up as to what was the underlying case that he had a warrant for. So the information for him having a warrant, that's one thing, but also what was the underlying charge that he had a warrant for. That will come up in conversation. If it moves forward to a trial setting, then that is something that prosecutors will attempt to try to bring up in a trial. The defense counsel has the authority or right to object to it coming into evidence in a trial, but the prosecutors will certainly try to admit that.
Could Clanson face federal charges just due to the digital nature of the evidence?
I don't see why not. I would say yes. And that is something that it can be brought into on state level and federal level, both. And so anytime someone has information that is similar to that on a digital way or something that may have crossed state lines, that's another way for federal cases to be brought. It can certainly be brought in both levels.
Are the parents' rights automatically terminated upon arrest?
Not necessarily. So that is something that Child Protective Services takes a look into. They do an investigation into the case because, again, at this time, the case is a charge, right? It's not a conviction. And so the Child Protective Services will do their own separate investigation to determine if their rights need to be completely canceled out or if there needs to be some other type of amendment done. Again, that's kind of on a case by case basis, also on a state by state basis, where the Child Protective Services have actual elements that they look into to determine if the child's rights or if the parents' rights can be actually just cut off altogether.
Now, we don't know how long this trial is going to take, but it's expected to take a while, like most trials. What happens to the child during this time? Could she be
Mm.
adopted before the case is even resolved, or would they have to wait until a conviction?
So, well, wait, before we say that if a trial is happening, we don't know if a trial may be happening or not. So, this person may have been arrested, right? They may be taking some type of plea offer or a plea agreement. We don't know yet. It can move forward to a trial. And if it does, then we would have to see again what the Child Protective Services Department determines what is best. So, they always look into what is the best interest of the child. Most of the time, they look into trying to find a family member that is stable, that is local, and that allows for the child to be able to continue in their normal process of life, doing the normal things that they normally would have done. And so that's normally the thing that they look for first is a family member, close relative that is close by that will not disrupt the actual flow of the child's life. And then, and only then, do they normally kind of look to outside individuals. An adoption process can take a year, years. So I don't know if an adoption process all the way may be something that could have been a actual final matter, but it is something that can be considered.
Now, the we were speaking about this. I mean, these are some heinous allegations here. Let's talk about just protecting the child's identity. Will the child's identity remain sealed during and most importantly after the trial?
I would hope so. In this particular case, the child is the victim, right? So, and I have to say the word alleged victim because that is the case here. Or in every case, we have to say the alleged victim, but the child is the victim in this particular situation. The judge has the authority at that time to seal the record to where the child's identity is not released to the public. So that is always up to the discretion of the judge in that particular court.
Can mental health be used as a defense in a case involving child sexual assault?
Again, that's going to be a state by state basis. When we talk about defenses, I know here in Texas, mental health can be a defense to most cases, to most charges. And so, yes, it can be here. I would presume so also in Wisconsin, but it's a state by state basis. So, if someone has a mental health issue, they don't understand the difference between right and wrong, or they don't understand exactly what it was that they were doing, that's going to be up to defense counsel to raise that in a trial setting. And so that is something that could be a defense, but it's up to defense counsel to raise it in a trial matter.
Could postpartum issues or trauma be used in any defense for the mother as well? Like if you were her defense attorney, is that something that could potentially work or help her situation?
When we talk about defenses, the penal code gives out specific defenses to each and every offense, right? So we could say, well, again, some type of postpartum matter or postpartum issues, could that go to mental health, right? I think that that is something that if a defense counsel brought it up, it wouldn't necessarily go to specifically an outright defense, but what it could show is that she was going through these matters and he could use that as a way to show some type of defense. But does it outright give a defense immediately? No. I'm going to say that that probably gives some type of mitigating circumstances, and something for a jury to consider.
If the mom claims coercion by Skyler Klassen, how would that be investigated?
So if she claims that, then again, I think that's going to be something that her defense counsel would bring up in a trial setting. Again, for her specifically, that the prosecutor's office, their job is just to bring the charges. All right, so they're going to bring the charges. More than likely, same charges for both of them because both were involved in this particular incident and everything that was done. So the charge will be brought against both of them. If the mother is saying that it was him, he forced me to do it, he coerced me into doing these things, her defense counsel, it'll be their job to bring that up to the state, either in pretrial negotiations, and if it moves forward to a trial, then a trial.
And we touched on this a little bit in the beginning. We don't know if this will go to trial, right? So, what is the likelihood that this case goes to trial versus ending in a plea deal?
That's normally just a case by case basis. Based off of the information that I have so far at this point, we know information changes, right? And information continues to develop as the case moves along. But as as we stand here today with the information that we currently have, an admission, then we also have pretty much blatant discovery that was found on his phone, right? So evidence there. We have a tipster who gave, something that showed that there was something on this person's phone. Based off of that, and also him having that outstanding warrant, right, in another county. I would say if I was his defense counsel, I would recommend some type of plea offer that involved him getting some type of mental help as well, because this is clearly something that is involving someone who has maybe a mental imbalance or something that's related to that in order for this to even happen. So if there was a plea agreement, then as defense counsel, I would be recommending some type of mental treatment in addition to the punishment.
What would that look like? Speaking of, the punishment, and speaking of, a potential plea agreement, like how many years potentially, what if you were his defense, what exactly would you fight for? How many years in prison? How many years, getting mental health? What do you think will be the best deal for both sides?
It really, again, this is, I know we hate this answer, but it really just depends. Because the thing is that he has multiple charges, right? So he has, I think it was like maybe 4 different charges that I saw. He has multiple ones. Each one of those carry a different punishment phase. So if it were, let's say, 2 to 20 on one, another one is, 2 to 99. Another one is 2 to 10. So it can vary. A judge has the authority to say, well, okay, well, we sentence you to a punishment of 10 years, and all the cases will run concurrently. And so that just means that then all of the punishment for each of the charges are for this 10-year punishment phase. So it really just depends on what the state offers first, then based off of what the punishment phases are for each individual offense that he has. And then also the state takes into consideration his past criminal history as well.
Now, police claim to have a lot of damaging evidence. How does a prosecutor just build a timeline to show the pre birth planning of alleged abuse?
So the police department will put together their packet. And so they'll put together a timeline for the DA's office. So they'll put together all of the information for the DA's office. So they have to be pretty steadfast in all the information that they present, because that packet that they present goes to a grand jury. It goes to a grand jury, and then the grand jury makes a determination on if there was enough probable cause for an arrest. And if so, then it moves on to a prosecutor. And so if there was enough information there, it automatically goes, like I said, to a prosecutor. So that timeline has already been created for them. And if there's anything that's missing, then the DA's office will work with the investigators to make sure that they kind of fill in any gaps.
Could prosecutors pursue life without parole in this case?
Uh, Again, I don't know the answer to that one. What I would say is that it depends again on the punishment that for the various phases. So whenever we have an offense, then that offense has a punishment phase. Most of the time, first degree felony cases will maybe 10 to 99 years in prison, right? If there's any type of extenuating circumstances, then the state has the authority then to ask for an enhancement. And so that could be something that they do if there is extenuating circumstances that allow for it. So it just depends. And so we would say that I think some of the cases that he has offenses for are first degree felony cases. And so the punishment range here in Texas is 10 to 99 for that. And so any person who has that charge could be facing up to 99 years in prison. So it's a pretty serious offense, but there are circumstances that can raise that up higher than that.
And speaking just of the defense, could the defense try to blame each other in court? Like, how could this potentially play out?
Well, they could do that, right? But it may be in their best interest to even try to work together to try to get each person the best plea agreement. And so sometimes that may be a strategy. It depends on the defense counsel strategy. once the defendants hire counsel. It'll be in their best interest to both hire separate counsel and not the same person. And then that way, if there is something, let's say that the young lady is saying, well, he forced me to do this, then her counsel at that time can state, okay, well, this was him, it wasn't her. And she was only doing it because he was forcing her. But if that's not the case, then sometimes defense counsels may work together in order to try to get the best outcome for both parties.
How long could a trial like this take from indictment to verdict?
It depends on how many witnesses that the state has, how many witnesses the defense counsel has. Trials like this could start at anywhere, I would say maybe 3 days. It can extend anywhere to months. It just goes back to how much discovery, how much evidence, how many witnesses the state intends to prove up and bring to court, and then how many witnesses, discovery, evidence the defense counsel plans to bring in as well.
How does media attention or, viral social media content affect jury selection?
Let's see. So what I would say to that, it doesn't necessarily directly impact jury selection. When we talk about someone that serves on a jury panel, the prosecutors and the defense counsel, they're not necessarily picking specific people. That what they're doing actually is eliminating people. Right. So you go in and the prosecutors and the defense counsel, they're asking questions of each of the individuals. And then they're taking time to see, okay, well, it does this person one meet the direct qualifications? Do they read and write the English language? Are they able to be here? Right, the different things like that. Do they have an explicit bias towards any of the things that are here? So those are the things that come out first. Then after that, each side has different ways that they can eliminate someone, and those individuals who are left are the people who are on the jury. Now, if a person has been exposed to media attention for a case, then the prosecutors generally during voir dire will bring that up and ask people in the jury panel, have you seen this on the news? Have you seen this on the internet? And how do you feel about it? Do you have a bias against it? Do you have, are you able to put that aside and be fair in this particular case? So they're asking those questions during voir dire in order to eliminate people who may have an explicit bias.
With the case like this one, with the evidence that, police say that they have dealing with the baby, dealing with alleged abuse, how do, just the prosecutor and defense ensure an unbiased jury with such an emotionally charged case?
Well, they do their very best, right? And that's how they are able to ask specific questions in voir dire. And voir dire is just asking questions of the jury panel, right? And so they're going to ask, again, we talk about just those direct questions first. Do you read and write the English language? Do you have any explicit biases towards someone who has been charged with this particular offense? Have you heard of these individuals before? Have you met them? Do you have any history with them? And so any person who has those things, then they may be asked to come up on a singular voir dire where they just ask that person questions outside the presence of the rest of the jury panel. And the questions there that are most important are, can you put aside those things that you may know or the things that you've heard on the media and things that you may have, let's say you went to high school with this person. Can you put aside things that you knew about that person from high school and only listen to the facts that are heard here today in this courtroom and make a decision based off of the information only that you found out here in court?
Well, this is a story that we will definitely be following closely. Bridget, thank you so much for joining me today.
Thank you for having me.
Both Klassen and Bishop are in the Dane County Jail. As we learn more updates in this chilling case, we'll be sure to update you right here on Law and Crime. For Law and Crime News, I'm Kennedi Walker.